Good evening. This is Andre Smith, Professor Smith, Smitty Bonton. You can call me whichever you like. This is actually the first episode of the Economic Justice Law Review. So I know some of you have seen our videos on Afro-Atlantic and jurisprudence. This is a slightly different. It's part of the same project, but a different strand. Here, what we're trying to do is become the online repository for scholarship relating to race, economics, and law. Currently, there is no journal out on the market that basically specializes on all these categories. And what we intend to do is to, instead of publishing original scholarship in this law review, we intend to be the repository. So what we're going to do is gather and collect race, law, and economic scholarship that's out and about throughout the country, bring it here, recategorize it, break it down, and represent it to you all, so that there can be one central place where we can kind of discuss these type of issues. Yes, there is the website, economicjusticelawreview.com. It is under construction, so it will be designed for us to have scholarly discussions about these works. At the moment, though, we are under construction. There's also a Facebook page, and there will be a YouTube channel. And so I hope you enjoy it, and I hope you're happy, on the one hand, to learn something perhaps new. And then secondly, I'm very glad to get things that I think are very important outside of the ivory tower and get it into public discourse, because I think it's too information to just be locked up. Okay, so today we actually have a very, 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 I mean, this is perfect for our first video review. We're going to review Andrea Freeman's Racism in the Credit Card Industry. Again, Andrea Freeman, she's at the University of Hawaii. I believe she's making a move to California. I don't want to be telling your business, Professor Freeman, but she's at the University of Hawaii with the great Charles Lawrence, Mary Matsuda, some good other good friends there, Professor Baker and whatnot. And so I'm just very happy to present this piece of scholarship because I think it's very important and very emblematic of what we're trying to accomplish here. So let's get to it, okay? So Andrea Freeman's Racism in the Credit Card Industry. It's in the 95th volume of the North Carolina Law Review, page 1071, year 2017. It's an excellent example of economic justice legal scholarship. It not only satisfies all the great criteria for good academic scholarship, it presents information vital to every person of color and those interested in justice. For discriminatory practices in the credit card industry have a direct and deleterious effect on the racial wealth gap. The harm is twofold. There is the extraction of interest from black and brown consumers and redistribution to shareholders of financial institutions, who, of course, are predominantly white. Then the dynamics surrounding racist credit card policies also presents multiple harms, or what I'll call often when we talk about economic justice, asymmetries to the structure of the supposed free market, which is likely then to reproduce further subordination in the future. In short, I'm very proud of this work. It's an important work because it corrals pretty much all of the important pieces of economic justice over the last 20 years and then adds its own very significant contribution. So how we're going to proceed is I'm going to not read the article itself entirely. It is 90 pages, so I definitely think you need to get the full flavor and get it yourself. However, what I did do is take a lot of snippets out, and I want to read some of them to you to give you a greater sense of precisely what she's talking about. And one of the best things I think about this is, again, she corrals lots of economic justice scholarships. So although we're going to talk about racism in the credit card industry, she situates it within the entire 20th century economic subordination dynamic, right? How after the Civil War, we have not progressed, and the racial wealth gap has basically maintained, if not widened, since then. So let's get to it. She starts with not a hypothetical, but an example of disparate impact or discrimination between two consumers. Okay, and so she says, based on the algorithm that assessed Karen, Capital One classified her in its City Roots segment and showed her two credit cards. Both cards sought to lure her in with a zero interest 6-month teaser rate. After half a year, the interest rate shot up to either 24.9 or 13.9%. In contrast, analyzing Thomas Burney after he clicked once, Capital One correctly labeled him as a white college graduate who skis, but predicted a salary higher than his actual one. The company's data software classified Thomas in its God's country segment and offered him a card with a relatively low 11.9% interest rate, right? Obviously, significantly lower than the one that was offered in the City Roots program. This type of discrimination against credit card applicants through algorithms and data mining is an unregulated but increasingly common phenomenon. For example, a 2008 survey found that although Black borrowers carried lower balances on their cards, they paid more interest. Specifically, a Black family that carried consumer debt with an average interest rate that made average monthly payments paid at least $100 more in interest on the debt than an average white family, despite the fact that the Black family borrowed less. This type of consumer racism dates back to the Reconstruction era and reflects an unbroken chain of laws and policies cementing racial economic inequality. Social norms and stereotypes serve to make this inequality appear cultural and personal instead of structural. Totally on point. Yes, we're talking about racism in the credit card industry, but again, this article is so very good because it situates it also within the larger framework of economic subordination. There are racial disparities in every aspect of credit card use, from the application process to the terms of the agreements to the need to forego necessary medical treatment and abandon educational opportunities due to excessive debt. She shows that even neutral terms can lead to racialized outcomes. Consider the application process. She writes, purchasing data from companies such as FICO to determine credit denials and terms affords credit card companies the opportunities to engage in indirect racial discrimination. For example, the companies often assess credit worthiness based on factors that stand in for race. Most significantly, because most of the United States is residentially segregated, neighborhood can serve as a proxy for race, right? Your zip code. Similarly, affinities such as professional associations and sports teams can point to income level or geographic location, indirectly providing insight into the consumer's race. So Professor Freeman then gives us a framework for how she's going to proceed, right? After giving us those hypotheticals and basically telling us eventually where we're going and the dynamics that are at play, she tells us that she's also going to explore the role that stereotypes about Black consumers play in creating and justifying racial disparities in credit. These stereotypes focus the blame for bad credit squarely on the individual, making legal reform and corporate responsibility appear both futile and unnecessary. Part two of her work looks closely at the two laws designed to address racial discrimination and inequality in credit: the Equal Credit Opportunity Act, the ECOA, and the Community Reinvestment Act, the CRA. Acknowledging that these laws neither deter nor provide effective relief for racial disparities and discrimination in credit, right? So on the one hand, we present the problem, and she does offer some solutions at the end. However, we know that tackling this particular issue is going to require probably more than a public coalition, and will require perhaps some protest actions or even agency by members of the Black community. Part three of her work proposes amendments to the Consumer Accountability, Responsibility, and Disclosure Act, designed to reduce or eliminate racial discrimination by credit card companies, as well as to promote economic growth in underserved communities. Rehabilitative reparations theory provides the model for these programs. And part three argues for similar but stronger consumer laws requiring credit card companies to disclose any racially discriminatory conduct and to compensate for it through significant investments into the harmed communities. I think that is going to be one of our principal solutions that we're talking about. And again, what I enjoy about it is, although it is a public solution as far as law is concerned, because it deals with disclosure, it requires companies to do something to tell the truth. But then after that, it asks Black folks ourselves to then seek and use the information. And in that sense, it trusts, right? Whereas the rest of the article also talks about the myth of inferiority that's promoted about Black people, where we distrust Black folks' ability to use information. Okay, so let's go into the background or the context regarding economic subordination. And ultimately, when she's talking about economic subordination in the 20th century and structural racism, it's not just because it's a bad thing. It is, but there's a consequence to it. So her point in the end is because of economic subordination in the 20th century, Black folks have a greater need for credit in the 21st century. So that sets up Black folks for the double whammy, having to use credit more often than others, and then having to use it under discriminatory terms. So she writes, economic history reinforces several key critical race theory principles: that racism is permanent, subject to relief only when white interests converge with the interests of those subject to racial oppression. That's Derek Bell all the way. That race is a social construct designed to perpetuate white privilege, and that law is a tool implemented to define race and enforce racial boundaries. So when she talks about law and its relation and enforcement of racial boundaries, she starts right after the Civil War and goes into talking about black codes as market exclusion. For those that aren't familiar with black codes, they were state laws that were passed in almost if not every southern state that basically criminalized almost every aspect of black life. So that through the convict leasing and sharecropping system, Black folks could basically remain de facto slaves, even if the law says you weren't, right? So she writes, to allow for broad discretion in arresting and incarcerating freed slaves, the Southern states enacted black codes that attach criminal penalties, including prison time, to common activities. For example, Mississippi Black Code criminalized all rogues and vagabonds, idle and dissipated persons, beggars, jugglers, or persons practicing unlawful games or plays, runaways, common drunkards, common night walkers, pilferers, lewd, wanton, or lascivious persons in speech or behavior, common railers and brawlers, persons who neglect their calling or employment, misspend what they earn, or do not provide for the support of themselves or their families or dependents. You can get locked up for this, right? So, and that's not enough. And all other idle and disorderly persons, including all who neglect all lawful business and habitually misspend their time by frequenting houses of ill fame, gaming houses, or tippling shops. I don't know what a tippling shop is, but apparently in Mississippi, you could get locked up for going to one if you were black. Thus, by criminalizing such innocuous and prevalent conduct, black codes allowed states and municipalities to continue oppressing newly freed slaves and restrict their access to potential economic opportunities. Pretty soon, we're going to talk about the Department of Justice report on Ferguson, Missouri, and see more or less the same tactics used to basically tax the citizens of Ferguson and St. Louis County to death. And also, if not, and once we get the money out of you, basically the fact that everyone has a warrant also excludes you from the marketplace. So what's passed is prologue. Further, despite the promise that freed slaves would receive 40 acres and a mule to work their own land, the government has yet to give reparations to slaves or their descendants. Instead, the federal government awarded up to $300 per slave to their past owners who lost their property. Black land ownership, right, peaked at 218,000 black-owned farms in 1910. So again, between 1865 and 1910, that's 45 years of what we call Reconstruction, right? But Reconstruction lasted a good 20-25. But once the 1890s came along, the retrenchment, the re-enslavement of blacks was a systematic program. And so in 1910, we have 218,000 black-owned farms. And after discrimination and exclusion by the United States Department of Agriculture over the following century resulted in that number dwindling down to 18,000 black-owned farms, a decline of 92%. And by 2007, 98% of all farms were white, and blacks retained little hope of regaining their foothold in agriculture. Parallel to the decline of black farming was the trajectory of black business, which peaked in the early 20th century in cities including Atlanta, Chicago, D.C., Knoxville, New York, East St. Louis, Tulsa, Oklahoma, and Rosewood, Florida. Unfortunately, whites who resented black economic success often responded to thriving black communities with acts of violence. New Deal programs, right? We had Franklin Delano Roosevelt became president for life until we amended the Constitution, all based off of his New Deal. But the New Deal programs designed to lift the national economy out of the Depression and to create important protections for workers largely bypassed blacks. For example, the 1935 Social Security Act provided a safety net for all employees, but excluded certain groups, including who? That's domestic servants and all domestic servants and agricultural workers. And so, if 90% of Black folks are working as domestic servants or sharecroppers, then you're entirely excluded out of the Social Security Act. Where whites who did other menial jobs were not. Where black labor was concentrated, in the same year, the Wagner Act granted collective bargaining power to unions, making negotiations for fair wages possible and greatly expanding the middle class. The act, however, allowed unions to exclude domestic servants and farm workers and provided no protection against racial discrimination in benefits, including health care, job security, and pensions. So the union movement went on and excluded black folks in the early and mid 20th century. How about residential segregation? By 1940, racially restrictive covenants covered 80% of the property owned in Chicago and Los Angeles. A racially restricted covenant is a covenant that goes in the deed or attaches to the real estate that says the owner cannot sell it to a person of another race. And as a matter of fact, these racially restricted covenants also foreclose selling homes in black neighborhoods to those outside of the race. And so here we have, again, the monopoly example of players being able to go around the board except blacks. And then when blacks are let into the game, the rules are equal, they're neutral, but we have to mount a comeback with just Baltic and Mediterranean Avenue. Unfortunately, the creation of the Federal Housing Administration in 1934 did little to alleviate the effects of private discrimination on segregation. Instead, the agency increased segregation through policies such as redlining, which rendered residents of certain areas ineligible for federal housing loans. Redlining began with the Federal Home Loan Bank Board's request to the Homeowners Loan Corporation in 1935 to create residential security maps for 239 cities. Again, the tactics are presented as neutral and having some type of actual concern, such as security, but we know that the actual consequence is racial subordination. Redlining allowed the FHA, a crucial part of Roosevelt's New Deal, to make home ownership possible for millions of white Americans, while excluding members of black and integrated communities from access to this crucial path to financial stability and wealth accumulation, regardless of their creditworthiness. Of the $120 billion, hold up, let me say it again, of the $120 billion in home loans administered by the FHA between 1934 and 1962, 98% of them went to whites. Similarly, between 1946 and 1960, less than 100 of the 350,000, say it again, less than 100 of the 350,000 new homes in Northern California financed by the FHA went to black families. FHA publications further discouraged integrated living by problematizing neighborhoods containing inharmonious racial or nationality groups. Okay, let's take it further. In conjunction with the FHA, the Servicemen's Readjustment Act of 1944, the GI Bill, right? A lot of people are more familiar with the GI Bill, failed to raise the black community's economic status because it provided for fewer benefits to black veterans than white veterans. Juan Perea writes a very good article, Doctrines of Delusion, that explores this issue. For example, under the GI Bill's directive to offer special support for veterans seeking to purchase new homes, less than 3% of FHA or Veterans Affairs loans went to non-white veterans. I'm not talking about black veterans, non-white veterans, 3%. So what does all that mean in relation to racism in the credit card industry, right? Well, here we go. And Professor Freeman ties it together beautifully. One significant result of the systemic institutionalized privatization of the Black community is a great need for credit. Without a safety net of wealth on which to fall back, even many middle class Black families live paycheck to paycheck, existing only one unforeseen expense, such as a medical emergency or a broken car, away from financial crisis. On point. In some ways, this type of urgent need for credit is unique to the United States because the U.S. government provides far less of a social safety net to its citizens and residents than most other developed countries. The absence of a social safety net in the United States makes credit an indispensable survival tool for both the lower and middle classes, a group often referred to as the 99%, because they are vulnerable to shocks such as illness, job loss, and economic depression or inflation. Additionally, residential and social segregation make it less likely that Black individuals in financial straits will have relatives or friends from which they can borrow. Um, Again, this is hugely important. If you ever thought about why Republicans and some conservatives and why moneyed individuals would be against national health care beyond the extra taxes, especially if the extra taxes wouldn't be that onerous, and we would have the benefits of less sickness, more workers losing days at the job. I mean, there's a big benefit to business of universal health care. So why would they be against it? Well, this suggests that banks and other financial institutions who loan money are perfectly fine or actually profit from the fact that you have to borrow in order to pay your medical bills. You have to borrow in order to pay your bills. So the idea of a basic income or a greater earned income tax credit or student loans or universal health care, those things that put poor people or middle class people on a more solid footing also makes them less apt to take jobs that they don't want, number one, or wages that they don't want, number one, and also allows them to avoid credit situations. Because again, companies eventually learned, however, that counterintuitively they could earn greater profits from their shareholders by targeting high-risk consumers who could not, in fact, pay their bills off in full, but would put some money toward them each month. These revolvers are often subsistence users, consumers who rely on credit cards to pay, at least in part, for life's necessities. This is reminiscent of company towns. Before there were unions, to build up the West, there was often railroads, mining operations, that would operate in the West after excluding Native Americans and what have you, and entice workers, white workers, to come out from the East. When you get there, the only game in town, the only stores in town are owned by the company, and the amount that they're going to charge you for your rent, for goods and services, necessities like clothes and whatnot, is going to be more than the wages that they promised you. So they're going to pay you the wages that they promised you. It's just that the amount that you have to spend will exceed it, and that will put you in debt and in debt to the company. And the laws back in the 19th century allowed for all types of ways to keep you paying, including attaching sometimes after here and after-born children. That is how indentured servitude and other chattel debt slavery occurs. Okay, well, let's talk about 21st century subsistence users. In 2007, twice as many Black credit card holders paid interest rates above 20% than white credit card holders. In 2013, over 40% of Black credit card users borrowed to pay for essential items, qualifying them as subsistence users. Without friends or family who possess extra resources to lend in times of need, in 2010, Blacks were more than 3 times more likely than consumers to pay off their credit cards bills by going to loan sharks, right? These payday loans. They were also more likely to declare bankruptcy due to credit card debt and to reach a settlement agreement with the credit card company. And the problem is that these types of settlement agreements often harm rather than help the consumer. So we're talking about huge wealth transfers from predominantly Black consumers to predominantly white investors. And credit card debt amassed to finance education also creates a burden for Black graduates who have the highest debt balances amongst college graduates. And due to the wealth gap, black students are more likely than white students to take on debt to pay for college. Additionally, disproportionately more parents incur credit card debt to finance their children's education. So medical shocks, education, and even just general subsistence are reasons why blacks without wealth, right? Again, got to make this point and make it very clear. We'll return to it that blacks and whites with the same income are not similarly situated because of the wealth gap. Whites with the same wealth as blacks, with the same income as blacks, have several times more wealth to rely on and other people with wealth to rely on, whereas blacks with the same amount of income basically are still often living check to check and perhaps maybe have some retirement savings. Medical bills present a significant cost that leads many black families to spiral into debt. So now that sets up the situation for why blacks are disproportionately dependent on credit. But how do we even find out whether or not we've been discriminated against with respect to the application with regard to rates? And even if we do suspect that we've been discriminated against, what's the solution? So she tackles this issue, right? It is difficult, however, to identify the precise disparities in the treatment of black and white credit card consumers because regulations do not require companies to disclose the details of their transactions, such as which cards they offer and sell to which customers on which terms. Keeping this information secret allows the companies to engage in discrimination that is very hard, if not impossible, for potential or actual plaintiffs to prove. In the similar context of discriminatory practices in the mortgage industry, Congress recognized and addressed this problem in the 1975 Home Mortgage Disclosure Act. So ultimately, that's where Professor Freeman is going to go and say that we need to mimic that and provide black folks with information about what's going on inside the credit card industry so that we can take over there from ourselves. Despite the lack of access to definitive statistics on credit card industry practices, two studies analyzed available data to conclude that race, isolated from socioeconomic status, has a significant effect on a user's ability to obtain a credit card and on which terms they receive. Specifically, in 2010, researcher Chi Jacqueline demonstrated that race affects the likelihood of obtaining a credit card, the number of cards owned, the average credit line per card, the conditions and fees attached to a card, and the factors necessary to establish credit worthiness. All of those are affected by race. A 2011 study published in the Review of Economics and Statistics, authored by Ethan Cohen Cole, entitled Credit Card Redlining, reports that living in a black neighborhood significantly affects a credit card applicant's ability to get a card and the terms of that card. Remember the hypothetical situation we saw that we read at the very beginning. The report documents that credit card applicants from white neighborhoods with risk profiles and credit histories identical to their counterparts in black neighborhoods receive approximately $7,000 more in available credit. And if you're using that money to purchase a home, to make a down payment, to pay for an education, to pay for medical bills, or even to start a business, again, that access to capital is what allows you to compete in the marketplace. It is a very important part of economic competition, the ability to have capital to enter into and exit markets. Professor Freeman also cites a few studies that refutes the myth of black inferiority, that the debt, consumer debt, the interest rates that blacks pay are not a product of some deleterious or prurient or reckless culture. Simon Firestone conducted a study published in 2014 concluding that blacks are less than half as likely as other groups to possess credit cards in the first place due to racial differences in credit card marketing. So the idea that blacks are enamored with credit is just false. A 2001 study by Sheila Ards and Samuel Myers, who actually was one of my professors at University of Maryland, who taught me economics of crime and law enforcement. I believe it at the University of Minnesota. Dr. Myers, thank you. Sheila Ards and Samuel Myers refutes the myth that blacks disproportionately overspend, fail to save, and are not creditworthy. The study reveals that there is no statistically significant difference in bad credit rates between blacks and whites in the richest and the poorest neighborhoods. In middle-class black and white households, where the authors note differences in bad credit ratings, they argue that disparities arise from discriminatory treatment in the credit market, not variation in personal habits. What they're missing, which is pointed out by William Sandy Darity and Derek Hamilton, and we're going to talk about them later, is that what we're missing is that blacks and whites in middle class neighborhoods that have the same income are not similarly situated. Because of the market exclusion over the last 100 years, whites have several times more accumulated wealth in bank accounts, in investments, and what have you, than blacks making the same amount of money. Recall the joke Chris Rock made about the fact that he, in the neighborhood with himself, Sean Carter, Jay-Z, and Mary J. Blige, three preeminent, star-powered, what we would think as very wealthy black people, they said their next-door neighbor is a dentist. Right? Not your super dentist, just an average dentist who also had wealth in the family to make the down payment, that it's his job to make sure to pay the mortgage because that house is also an investment that is likely to produce wealth, and the family structure supports that. So Professor Freeman goes further in talking about this and trying to debunk this myth of black inferiority. She goes into a segment of her paper talking about welfare queens and thugs and how that projects and exacerbates, maintains, propagates the myth of black inferiority. And she says that therefore the trope goes that black women should have restricted access to money and credit because they're thought of as being lesser economically. And she puts hip hop to the task with respect to this notion or stereotype. Then she cites Regina Austin, University of Pennsylvania, she eloquently summarizes the common understanding of the relationship between blacks and money as follows. It is assumed that blacks do not earn their money honestly, work for it diligently, or spend it wisely. When blacks have money, they squander it and cannot save it. Austin further explains that through this lens, the companies or individuals who seek to exploit these assumed propensities to remain ignorant of financial best practices and overspend, they remain blameless. The onus on blacks to wise up or suffer the consequences, caveat emptor. For those that know me know I try not to bash other black folks, and I'm a hip hopper, so I defend it a lot. However, one of the songs that I've always had a big issue is Kanye West "Click," when he says, I'd rather go ignorant, blame it on the pigment." Right, suggesting that he's going to spend money recklessly because he's black. And regardless of whether that's the culture that's promoted, it's not the culture that we have to accept or we propagate ourselves, right? Okay, so Professor Freeman then talks about some positive legal developments, right? Information is power, information is capital. And so while there may not be a great deal of hope for absolute fairness, she does put together some proposals that perhaps can push the market structure to be a little bit more fair, and so that blacks, with our own ingenuity and strategic maneuvers, can take over. She writes that black consumers report that some of the provisions of the 2009 Credit Card Accountability, Responsibility, and Disclosure Act improved their borrowing experiences. For example, the Card Act requires credit card companies to include clear statements on credit card bills describing how long it will take to pay off the balance if the customer pays only the minimum amount. In one study, 37% of black households reported that they pay more toward their monthly balances due to receiving this information, thereby shortening the specter of their debt. The Card Act also reduces the fees that companies can charge for exceeding credit limits and making late payments. 32% of black households consequently reported paying fewer fees for exceeding their credit limit, and 25% say that they paid fewer late fees. Further, the amended Card Act restricts the conditions upon which companies can increase interest rates, which has led to a self-reported 25% decrease in the amount of interest that the companies charge black households. So basically, with better information, when you know better, you do better. She concedes that consumer law is ill-equipped to police or redress inequitable treatment. Historically, consumer law has offered very limited protection to consumers. And again, Professor Freeman is an expert in this area. Later, we're going to go over some of her work talking about food security and other issues about discrimination and subordination in the marketplace. Its restricted nature in large part reflects its position in the consumer capitalist society. Consumer law seeks primarily to encourage, not inhibit, consumption. The first, the Economic Equal Credit Opportunity Act, the ECOA, allows plaintiffs to bring suits against credit providers for unlawful discrimination. Unfortunately, however, these suits rarely resolve in plaintiffs' favor, often because they require them to prove intentional discrimination, a nearly impossible task so long as folks know how to play the game. The second, the Community Responsibility Act, the CRA, takes more of a preventative approach to the problem. It requires lending institutions to serve the needs of the communities in which they are located. Banks rarely follow this admonition, however, due to erratic enforcement and their ability to flee low-income communities and relocate to wealthier neighborhoods of service online constituents, so it's easily avoidable. She writes, to date, there have been only 3 major settlements in favor of plaintiffs alleging discrimination by credit card companies on the basis of race or national origin. So although there's laws on the books, they don't seem to be quite effective, and therefore, again, taking our action in our own agency into our own hands, although may not what we ought to be required to do, is what we must if the racial gap is to be addressed. In this era of post-racialism, overt racism is socially unacceptable, such that credit providers rarely, if ever, make blatantly racist statements. Consequently, plaintiffs consistently lack smoking gun evidence of discrimination. Nonetheless, the Supreme Court has not yet decided, whether plaintiffs may rely on statistics to prove discrimination under a disparate impact analysis. This uncertainty leads to confusion and inconsistency among the lower courts. And because the law does not require credit card companies to collect and report data on the racial breakdown of their customers and applicants, plaintiffs rarely have access to the statistics they need to provide discrimination under a disparate impact theory. So, and if Professor Freeman knows that, credit card companies know that. The law defines, the ECOA provides that it is unlawful for any creditor to discriminate against any applicant with respect to any aspect of a credit transaction on the basis of race. The law defines an adverse action as a denial or revocation of credit, a change in the terms of an existing credit arrangement, or a refusal to grant credit in substantially the amount or on substantially the terms requested. As part of an initial challenge to an adverse action, an applicant is entitled to a statement of specific reasons for the action by the creditor. A creditor may not inquire about a person's race or national origin in relation to a credit transaction, including persons other than the applicant, but may inquire into an applicant's permanent residence or immigration status, right? See, that's the way around a lot of this. If an individual suspects that a credit issuer has violated their rights under the ECOA, they may complain to the creditor, ask the state attorney general's office for advice. Again, do you have a Democratic or Republican administration? It matters. Sue the creditor in federal court individually or as part of a class action, or report violations to the appropriate government agency. In the event of a suit, the ECOA allows for actual damages, punitive damages, equitable relief, and your attorney's fees. To date, there have been 3 major ECOA investigations into race or national origin discrimination by credit card issuers, resulting in settlements. And all three of them involved Latino borrowers, discrimination against Latin borrowers. The CRA, the Community Reinvestment Act, authorized regulators to make periodic assessments of banks' compliance with the mandate to meet the needs of traditionally underserved communities located within their purview. This is particularly sensitive to me because even before I went to law school late, I went to law school at age 27. When I graduated from the University of Maryland back in the 90s, one of my first jobs was selling mortgages, second mortgages for household finance. And I was in southern New Jersey at the time, and I made lots of loans. I was making decent money. I didn't really like it, but at the same time, the product was not obviously meant to extort or support. was usurious, to say the least. And they advertised themselves as second chance credit, but when we would try to get the loans through, they basically still needed a credit rating and financial profile that could have gotten them a loan at Chase Bank or something like that. We were really just preying on those who were unaware and unwilling or unable to shop for better deals. And I made that point. I began to complain a little bit because I was trying to sell some loans in Camden, New Jersey, and there was always a reason why we couldn't get this home mortgage loan. And we get some people with good credit or with plans to rehabilitate their homes to keep the value, and they would get denied for reasons that just didn't seem similar to what was going on elsewhere. I made a complaint about that, and it was funny because all of a sudden, one of like the district managers comes down to me from New York to have a special meeting with me and sell me. He's a salesman, right? We sell mortgages. So he has me in the office and he's selling me, right? He's selling me on household finance and how much they do for the community and whatnot. And of course, he never addressed the specific issue that I brought up. And again, as you might guess, that plus a lot of other things eventually sent me to law school as an older student. The CRA authorized regulators to make periodic assessments. The CRA assessment process appears to be ripe for abuse, though, because it lacks definitive guidelines allowing wide latitude for discretion. Again, I mentioned before, I'm an administrative law teacher, and very soon we're going to talk about discretion, or the critical race theory of administrative law, and how racism and subordination lies within the application of discretion, which, interestingly enough, flies in the face of much critical race scholarship about statutory interpretation and other jurisprudential constructs. We most often want judges to have the ability to inject a lot of discretion to consider minorities. However, when we have a situation like the Trump administration, then we have an executive department that's hell bent on subordination, and the discretion within statutes, within their bureaucracies, allow them to change the rules midstream and cause harm to Black communities. Despite the occasional and notable opportunities that the CRA affords for greater community investment, leading scholars have criticized the law extensively from its inception. Many banks simply move out of underserved areas, leaving a gap that exploitive fringe lenders are delighted to fill. In Chicago, for instance, low-income neighborhoods are home to only 2.3% of the city's full-service banking branches. Moreover, savvy banks such as J.P. Morgan and Wells Fargo create partnerships with check-cashing outlets and payday lenders that remain to serve the areas that the banks no longer occupy. Additionally, the CRA does not establish concrete guidelines for best practices, such as quotas for lending to minority individuals and businesses. It also does not require regulators to use an objective scale to determine best practices. Regulators simply compare banks to each other, and the different regulators do not coordinate or align their criteria. Significantly, banks that do business over the internet can evade the CRA assessment due to their difficulty in accurately identifying geographic scope of their clientele in the first place. So with all of that, Professor Freeman, of course, wants changes. Now, before she heads to her changes, she wants to talk about rehabilitative reparations, right, to justify it. Now, I argue, I don't disagree with her approach of going into rehabilitative reparations. However, I do think there are other ways to get at justifying federal statutes and a correct or more equitable interpretation of federal statutes. And we'll talk about that in works by Jeffrey Parsons Miller, and also the case of Bob Jones versus United States. I believe both Jeffrey Parsons' work on originalism in the Constitution, as well as Bob Jones University versus United States, gives critical race theorists ample authority and support for arguing that interpretations of federal statutes that subordinate or maintain or propagate or advance the subordination of one group over another, or subordinates Black people, is inappropriate and unreasonable and can be set aside under the Administrative Procedures Act and Citizens versus Overton Park. But she does go over reparations, and she talks about rehabilitative reparations focuses on group as opposed to individual compensation for past harms. Again, I've written on reparations, or I've written in conjunction with Carlton Waterhouse on taxation and reparations, and he is also one that believes that reparations ought not be paid to individuals. It ought to be paid to blacks as a group. Yes, there are issues with that. Who runs the group? What are the funds? How and whatnot? And we discussed that, but Professor Freeman is also one who promotes rehabilitative reparations. Slavery disclosure laws embody this theory of rehabilitative reparations by holding corporations, in addition to governments, responsible for their role in perpetuating and exploiting economic disparities. The CARD Act should require credit card corporations held to discriminate against consumers based on race to make significant financial investments into the harmed communities. These reporting requirements should follow the model provided by the Home Mortgage Disclosure Act and include the race, gender, and income of credit card applicants and borrowers, in addition to price data. Although the failure of the HMDA's disclosure requirements to prevent racial discrimination in mortgage lending casts some doubt on the potential of disclosure to lead to reform, it is possible that HMDA simply does not go far enough in its reporting requirements. So what we're doing is we're extending slavery disclosure to discrimination disclosure, right? People heard about Georgetown University and other places that once it was discovered that they had profited from slavery hundreds of years ago, the demand for them to divest or at least do something special to atone for reaping those rewards off of slavery. Professor Freeman wants to extend that principle to the credit card industry, right? So that that those credit card companies that have discriminated against Black people in the past, that we out them, that the disclosure laws gives us the information that, number one, embarrasses them and hopefully propels them to give back to the community, and number two, gives Black consumers better choices. Several organizations, and I would say again, extending slavery disclosure to discrimination disclosure, we saw earlier that Black folks responded well to simply having more information. And why would we think that they would not? Several organizations, church leaders, and politicians supported these disclosure campaigns, which included boycotts against J.P. Morgan student loans and insurance policy firms Aetna and New York Life. J.P. Morgan and Wachovia subsequently issued public apologies for the company's past ties to slavery. Aetna also apologized and established a minority internship program and diversity scholarship fund. J.P. Morgan similarly created a $5 million scholarship fund for Black students in Louisiana. Not stopping there, advocates and activists have gotten cities to enact disclosure laws requiring businesses in those cities to disclose whether they profited again from slavery. City of Los Angeles, the state of Ohio, Detroit, Philadelphia, San Francisco. There are also slavery disclosure laws on the books in Berkeley, Chicago, Milwaukee, Oakland, Maryland, Illinois, and California. Professor Freeman hopes discrimination disclosure laws can produce a positive effect. So let me take a breath, right? That is Professor Freeman's racism in the credit card industry. And I hope you now agree with me that it presented quite a bit of useful information. Again, I think one of the best things about it, not only is it warning us or signaling to us that there is racism in the credit card industry, that we have to lobby and use our political capital to change the laws and the interpretations of laws regarding this issue. It also means that where our interests diverge, where there is no coalition or there's no taste for change in laws and regulations, that Black folks need to have this information so that we can make better choices, that we can shop a little harder to compare and maybe even raise a little fuss when we believe that we're being discriminated against, because the statistics show that you are getting more often than not a raw deal. Again, I think that one of the best things about this work is how she situates it within the chronology of economic justice since the Civil War. I have used the monopoly example often. I will kick it again. The financial position blacks are in now is not unlike a player in Monopoly who's prevented from going across the board for 10, 15, 20 rolls while the other players go along and acquire property, improve it, and do what have you. And so when the excluded player is let in the game under the same terms as the and rules as the others, the game is not all of a sudden fair. The game is not all of a sudden fair and equitable because the players that have been in there originally have much more wealth to use to their advantage, and they've also bought up the best properties, and all that's left for the excluded players usually Baltimore, Baltic, and Mediterranean, the little cheap purple chumpies on the left side. And that's the situation we're in. Moreover, we're not talking about advancements, and all you're left with is a $200 salary to go around the board, and that doesn't even rise with inflation. It's scary how much it is like today, where your even if you get a 1% raise, if the cost of living, if inflation is up 2% and you only get a 1% raise, you're actually getting paid less this year than you were getting paid last year, right? And so slavery didn't end till the 1940s. The Civil Rights Act doesn't come about till 1965. So we're talking about when we're talking about where black folks are when it comes to capital accumulation in 2017, we're talking only 50 years. Right, we're only talking 50 years after several hundred years of subordination, after hundreds of years of redistributing the wealth from slavery and Jim Crow apartheid by transferring the wealth from black to white over those several hundred years. I'm actually quite proud at what we've done in the last 50. Again, that's one of the things that I would have liked for Professor Freeman to incorporate. Her source list is fantastic, and as a matter of fact, we're gonna jump on it and cull a lot of those sources into our grand bibliography for the Economic Justice Law Review. However, I think it could have been helped by explicitly citing to Douglas Blackman, Alex Lichtenstein, other scholars have talked about the sharecropping convict leasing entry. Because again, Douglas Blackman's 2009 Pulitzer Prize winning book, Slavery by Another Name, convincingly demonstrates that slavery itself, de facto slavery, sharecropping, farming land and just not getting paid at all except for a place to live, that slavery did not end until the 1940s, and the convict leasing of those black codes were there to make sure you didn't complain. If you complained about not getting paid as a sharecropper, we were going to find some charges to throw you in jail and make you work in coal mines and even worse places. So because of that system, slavery did not end until the 1940s for almost 90% of black folks, because we were highly concentrated in the South up until that time. And that also inspired some of the great migrations to the North. She does, in fact, cite Daria Roithmeyer and her great work on racial cartels and built-in discrimination. Locked-in segregation is what she calls it, locked-in inequality. She does a lot of great work dealing with the housing market, the National Realtors Association and their racism, the redlining, the federal housing regulations. What you don't see in a lot of other scholarship is her reference to labor unions, right? And how that black folks and Latino workers, those that were agricultural workers and domestic workers. So even if you move to the North and you still worked in agriculture, or women who work as domestic workers, you're still excluded from being in a labor or collective bargaining as a labor unit. You are even more importantly excluded from Social Security, right? So where Social Security is designed to keep old folks off the street, we don't want people dying of hunger during, like we had in the Depression. It doesn't speak well of your country and its system. We are excluded, and we're talking about, and that effect carries forward to today, right? That black folks that are retired now and retiring now, who were agricultural or domestic workers previously, are suffering the lack or this disproportionately less amount of capital that they're receiving in their later years. There's also inheritance. I've talked about tax laws that help keep subordination in place, and I think Professor Freeman also refers to Ian Ayres in some of his groundbreaking work about just straight up consumer purchasing. Ian Ayres out of Yale University has did a fabulous work back in the 90s that empirically showed that black women get charged higher prices for in car buying, right? So again, we're talking a very similar instance, car buying, where we're not sure what is the correct price of the car. We're not sure what others are paying for the same car. It's very similar to credit cards, right? We're not sure what is the appropriate rate. We're not sure what others are getting. And in those instances where information, a central tenet of a supposedly free meritocratic market, is asymmetrically distributed to us. And not only that, when we talk about the stereotypes, the market information is asymmetrically imperfect with respect to information about us. So it's asymmetrically imperfect with respect to information provided to us. It's asymmetrically imperfect with respect to information about us. Again, I appreciate her use of statistics. The idea that in order to combat this myth of black inferiority, we have to debunk this notion that black people, on average, are prurient, reckless, wasteful, inefficient, etc. She notes that yes, it is a fact that blacks are more likely to use credit cards for subsistence. But what is absent, and what I would hope that she can inject later, is again William Sandy Darity and Derek Hamilton. Darity is at Duke. He's pretty much the preeminent, or at least one of the, but I think the preeminent black economist in the United States today. And lately, and I would say in the last 5 to 10 years, one of his biggest notions, one of the biggest theories, or what he's trying to get across most stridently, is that blacks and whites are not similarly situated. So when we see this comparison of what black people do and what white people do, and we say that because this person made $50,000 and that because this person made $50,000, they should act the same, that's just not true. Because again, black folks have less accumulated wealth than that white person that makes $50,000 because of the GI Bill, because of Social Security, because of labor unions, because of inheritance, because of consumer purchases, because of all these dynamics that have happened over the last 100 years. No, you can't just get over it, right? These market structures cause today's market to be frayed, and the claim that the free market produces merit becomes false to the extent the structures in the marketplace are imperfect. We're going to talk about that even a little more specifically. Again, she mentions that redlining, the algorithms, targeting, that these are the 3 ways in which credit cards are discriminatorily sold to black folks. She also talks about the myth of black inferiority and the lack of empathy that perpetuates it. And she talks about hip hop thugs, welfare queens, and it was interesting. And it was actually, I could see her trying to make sure she balanced it, because there's arguments on the one hand that say that there's a reason to reject rationality if you know the game is rigged, that the purpose of hip hop is to not accept this game. But I would say this, using hip hop, I think, is as a proxy for black culture is, it's harsh to call it distracting, but it requires so much more of a discussion that I think it takes away from what was already phenomenal about this paper. I think Regina Austin's quote and some other discussion about stereotyping generally. I think there's a lot of legal scholarship out there about stereotyping generally. And I think relying on those, even if that was a shorter discussion, would have been perhaps a little more appropriate in this context, because the discussion, when it focuses on hip hop, I'll even say this, even when it just focuses on hip hop, it leaves you wanting for more of discussion on that, and therefore takes you away from the discussion of credit cards, as well as it kind of contradicts itself, right? On the one hand, to say that the myth of black inferiority is perpetuated and used as the um, trope to or ruse to not, or the excuse not to change the laws, well, then injecting a discussion of hip hop and its culture, while I understand that it was approached with a sense of balance, seems, especially to the non careful reader, to cast blame and aspersions on Black folks themselves, or at least a specific portion of Black culture, that being hip hop. And the retort could always be, and again, this is why it requires so much of a longer discussion. We know that country music references drugs and lasciviousness probably more than hip hop. Punk rock, death metal, the movie industry, the pornography industry, all types of industries that are quote unquote raced white, um, um, seem to escape the same type of scrutiny that hip hop um, garners. But what I will do is concede that to the extent hip hop is used, right, to the extent it is used by the dominant culture to promote stereotypes, I do agree with her in that respect, because it does mask the fact that blacks do not use credit flagrantly, that blacks as a whole do have a adequate discount rate, that we do plan for the future and have a sense of thrift. um, and so I would end this by kind of describing how it fits within, or how we would categorize this within the greater framework that we're trying to establish here at the Economic Justice Law Review, right? The overarching theme that I've come up with, or trying to develop, when it comes to marrying so-called critical race theory, or the discussion of subordination in law, or group subordination law, and marrying it with law and economics, or this idea of a market, a meritocratic market. It's hard to say free market, because what I'm arguing is the free market, the one that they say excuses their conduct, that excuses all racial dynamics or whatnot, it absolutely does not exist, and they know it doesn't exist. All right, going back to my time at University of Maryland under Dr. Myers and Dr. Rhonda Williams and all those, they taught us from the very beginning that when the free market, the supposed free market, requires it is for assumptions that everyone is a profit maximizer, that everyone has can compete in any market they choose, and leave any market they choose. That there's perfect information. That there's perfect information about everything in the marketplace. That there's no transaction cost. So we know from the very point, from the very beginning, economics as a mathematical construct is interesting. It gives us tendencies or what have you, but it already tells you from the beginning it's not true, right? That the extent to which everyone does not seek profit, the extent to which people cannot enter in markets or leave markets, the extent to which information is imperfect or absolutely unavailable, and the extent to which there are taxes and pollution, crime, and other transaction costs, we know that the fair market does not necessarily produce things meritocratically. We also know that the government feels a responsibility under the Commerce Clause to correct those imperfections in the marketplace, right? Fraud laws, public education, all these things, environmental regulations, these things are there to try to make the market more perfect, right? To bring it towards meritocracy. They know it's not there, and the task is to try to create a market that better does so. Well, as a critical scholar who also writes and studies economics, then what we add to this conversation is that not only is the structure of the market imperfect, the structure of the market is asymmetrically imperfect, meaning that blacks and whites have different dynamics with respect to subordination or the imperfections of the marketplace. Black folks are less because of intergenerational wealth accumulation, blacks have much less wealth to compete, right? In order to compete in a particular marketplace, I have to have capital to enter into that marketplace. I need to have funds and able to start a business to withstand losses, etc. And we know that because of intergenerational wealth accumulation, Blacks have far less capital than whites have to enter into any market that they so choose. So there we know the market is not only imperfect, it is asymmetrically imperfect. Information, again, this is a big one. The idea that meritocratic outcomes come from perfect information. We know that information can't be perfect. All we're trying to do is make it better. But Black folks, the information being imperfect, it is asymmetrically imperfect. The information that is known about Black people is particularly false, and the information available to Black people is much less than is available to others. And part of that is also going back to because of a lack of intergenerational capital. Transaction costs. We know that, again, I rail about informal taxes on Black people, policing for profit, and just the entire criminal justice system heaps transaction costs on Black folks, environmental racism, inequitable taxation. We could even go to tort law and the disparities in judgments with respect to torts and to lawsuits and damages. To show that the transaction costs are asymmetrically distributed between groups. And then going back to profit maximization, we can talk about hate crimes and other forms of racism that, number one, can just drive Black people crazy, right? PTSD, however you want to describe it. And then secondly, when it comes to rationality, it also racism and things like that cause Black people to just withdraw from the market. So Rastafarianism or the MOVE organization, these folks, because racism got so bad, decided that they want no part of the system itself. And that also not only reduces the amount of Black capital we have, that lack of participation also hurts national gross domestic product. So it's not just a Black problem, it's a United States problem. So here, when we're talking about asymmetrical transaction costs, interest. Right? Interest is not the cost of the thing. Interest is the cost of the money you use to buy the thing, right? Interest is the cost of money. It is a transaction cost on top of what you're paying for the goods and services. It's just like taxes. And so to the extent we are paying more interest in a similar situation than others, then that is an extra tax. That is an extra asymmetrical transaction cost that we bear that then not only transfers capital from one group to a next, it sets up a market that is going to reproduce the subordination in the future. Asymmetric perfect competition, right? Access to credit and to compete, right? The racism, Blacks have less opportunity to acquire credit cards, and it even showed that amongst so-called similarly situated folks with the same credit score and the same amount of income, Blacks are given less in credit. So when it comes to competing, starting a business, etc., right, we have those asymmetric. The lack of capital means that competition is not only imperfect, it is asymmetrically imperfect, and racism in the credit card industry is part of why that is. We also have, again, the asymmetrically perfect information, the myth of Black inferiority. Professor Freeman deals with this idea that the information, the skewed information, the false information about Black people skews the market. This is a fabulous, direct example of how the myth of Black inferiority is an example of asymmetrical market imperfections and has a direct effect of allowing racism in the credit card industry to remain and flourish because people do not believe that there is a problem, because the reason why Blacks just don't have capital in their minds is just because we are lascivious and lack self-control when it comes to money. And again, when it comes to asymmetrically profit maximization, we can go to hip hop. We can talk about the idea that when it comes to rationality, the idea that long-term wealth and security is better than enjoying and spending all your money in the short term. Well, yes, but no. because hip hop comes from a culture, and it was produced in a cauldron of privatization and degradation in urban cities where most people, or not most people, but a good amount of people understand that they're not going to live until they're 50, 60, 70, 80 years old. And when they look in their neighborhoods and they see the people that have lived their lives that long, that have lived a good, clean life, otherwise they wouldn't be here, are still in a financial predicament no different than they are at 18, 19, 20. And so the idea of not living for today, of having a discount rate for some greater, grander day 30, 40, 50 years from now is just not something that seems rational to those people in that particular circumstances. That's again, truth, rationality, and all that is relative to the perspective and the circumstances in which you find yourself. And so when it comes to profit maximization, we can see number one, our discussion of some black folks, because of racism, because of poverty, because of intergenerational wealth deprivation, just reject the game entirely. And then we also have the second portion where, because of racism, because of I am trying to play this game, and because the market conspires against me in structural ways, that at a certain point, black folks withdraw from the system, and that helps basically no one. So the solutions, again, Professor Freeman talks about the solutions. On the one hand, there is the responsibility, there is agency that black folks, to the extent we are on our own, to the extent there is not a public coalition to do anything more stridently, we have to shop, we have to negotiate, we have to share information with each other. That is also part of capital, social capital. There's financial capital, the money I have, the stocks and bonds that I have, the human capital, what I'm able to do, what I know. That's human capital, regardless of what any money I have. There's political capital. Do I have senators, politicians? Do I have connections with them to get things to happen? And one of the things that's least talked about is social capital, the connections between folks that have all these skills. The financial, the human, the political capital can't be deployed efficiently without the social capital to talk with each other, to connect with each other, to trade one for another where it's going to be most advantageous. So those are things. One of the things that we can do to advance is for us to not perpetuate the myth of black inferiority, for us not to repeat statistics or stories about what we've heard about other black people doing bad, or making blackness synonymous with poverty, and whiteness synonymous with wealth. Those things perpetuate the myth of black inferiority, and is not helpful towards any type of equality in property. Another solution that she does not talk about, again, I'm going to mention it again, is critical race theorists in law schools have not dealt with administrative law in a sustained way. And here we're talking about in one of the laws that she talks about, the Community Reinvestment Act, is administered by the Office of the Comptroller of the Currency, right? And the Comptroller of the Currency is going to have certain discretion to regulate banks, as she described. And so according to Citizens versus Overton Park, a case written in the 1970s, early 1970s, by Justice Thurgood Marshall, holds that the federal judiciary can set aside even very small decisions made by federal arbitrators, right? What we call informal adjudications, decisions within their discretion. And we can sue them. We can actually challenge whether they've abused that discretion. And here, where we're talking about the OCC, to the extent they have guidelines and whatnot that seem to exacerbate racial discrimination or the racial wealth gap, then we need to call them out for being for instituting and implementing rules and adjudications that are inappropriate and unreasonable, and therefore set aside. Again, while rehabilitative reparations provides kind of a moral justification, we also have a legal one, in that Jeffrey Parsons Miller at NYU did some research into the necessary and proper clause. And he argues that the original understanding of necessary and proper comes from corporate charters at the time. That at the time, necessary and proper was often fine when you start a corporation and you give the officers the the authority to do things that are necessary and proper with respect to the corporation. The interesting thing is that proper had an independent meaning. Now, sometimes you had corporate charters that said necessary, sometimes you had proper, sometimes you had necessary and proper. So what did the ones that had proper by itself, what did that mean? It meant then that you could not, the rules and actions of the corporation, of the officers, could not disadvantage one class of shareholders against another. That is impactful. That is a huge. That if we incorporate that definition and that understanding of necessary and proper, that originalist meaning, right? Justice Scalia would be proud, right? The originalist meaning of what the people understood, not what the framers' intent, what the original people, what the people understood necessary and proper to mean, means that no, we cannot have regulations and interpretations that divide, that exacerbate the racial wealth gap, that disadvantage one group of citizens versus another. We also need to take advantage of Bob Jones University versus the United States, where we also held that Bob Jones University, the IRS was not allowed to give tax exemptions to racially discriminatory outfits, that they cannot call themselves charitable. They're not going to be argued that they are charitable. They fit within the definition of charitable if they are racially discriminatory. And to make that decision, the Supreme Court says that Congress does not intend for its statutes to increase racial inequality and subordination. Remarkable decision, and we need to take advantage of it when we're arguing that Congress does not intend for guidelines and other regulations and adjudications within the bureaucratic departments of government that they cannot exacerbate racial discrimination and the racial wealth gap. So all that said, there is hopefully an interest convergence. We hope that Professor Freeman is right, that greater disclosure of credit card statistics, their operations, and whether or not their credit decisions are based on race, and publishing them can have a much better effect on the market, can help us Black folks take their own agency and their own authority and shop and negotiate for credit on terms that are more favorable, and thereby help close the racial wealth gap, because equality cannot just be in neutral rules. It cannot just be in a equal notion of physical or occupational liberty. That also equality also requires more equitable distribution of property. And Andrea Freeman's racism in the credit card industry goes a very, very, very long way to exposing why the situation is the way it is, and a situation that maintains the divide and offers solutions for ameliorating the situation. So all in all, a fantastic piece of scholarship. Congratulations, Professor Freeman. And our next video on the Economic Justice Law Review blog will be to review Carmen Gonzalez's environmental racism. So through her work, we're going to talk about environmental racism and the concept of asymmetrical transaction costs. Thank you, and I hope you've enjoyed today's discussion.